Assalamualaikum. For the case study that we pick is Teh Guat Hong versus Perbadanan Tabung Pendidikan Tinggi Nasional PT-PTN 2015 MJLU 213. For the reference detail, this case was here in Court of Appeal Putrajaya, Malaysia. The date of decision was in 12 March 2015. The status of the case is the appellant by Teh Guat Hong was allowed against the High Court judgment by Court of Appeal.
The appellant, a first-class LLB graduate from the University of London, obtained an education loan from the respondent to study at ATC College. Initially, she expected loan exemption based on the 2003 circular, which waived repayment for first-class honours students. However, a later disclaimer revealed that this exemption only applies to IPTS students with land-accredited courses. Despite obtaining a land certificate, her application was rejected. She now seeks judicial review, arguing that the decision is irrational and denies her legitimate expectation and rights to be heard.
The case of Teh Guat Hong versus Perbadanan Tabung Pendidikan Tinggi Nasional 2015 MJLU 213 involves Malaysian law pertaining to education and student financing. The key legislation applicable in this context would likely include four types of act. The first act is Perbadanan Tabung Pendidikan Tinggi Nasional Act 1997, Act 566. This act established and governs the Perbadanan Tabung Pendidikan Tinggi Nasional, National Higher Education Fund Corporation or PT-PTN, which provides loans and scholarships to Malaysian students pursuing higher education. The second act is Education Act 1996, Act 550. This act outlines the legal framework for education in Malaysia, covering matters such as administration, curriculum, and funding of educational institutions. The third act is Contracts Act 1950, Act 136. This act deals with the law relating to contracts and agreements in Malaysia, which could be relevant in cases involving loan agreements or contractual disputes related to educational funding. And the last act is Civil Law Act 1956, Act 67. This act applies to civil law matters in Malaysia and may provide general principles relevant to the interpretation of legal issues in the case. These acts likely played a role in shaping the legal argument and decision in Teh Guat Hong versus Perbadanan Tabung Pendidikan Tinggi Nasional, particularly regarding issues related to student loans, contractual obligations, and education financing under Malaysian law.
The next part is legal argument. First, appellant argument. The appellant emphasized that the respondent authority must be derived from a statute. They cite the precedent set in RV panel on takeover and mergers ex parte Datafin PLC and others in 1987 QB 815 to support this position. By examining relevant section of the Perbadanan Tabung Tinggi Nasional Act 1997, they are argued that the 2003 circular is backed by legislative authority based in both the Minister and the Perbadanan. As reinforced by cases like Laguna di Bay Sendirian Berhad v. Majlis Perbandara Subang Jaya in 2014, 7 MLJ 545. Next, the appellant contend that the 2003 circular meets the criteria for administrative quasi-legislation. They cite Professor Chen's work on administrative law and highlight the dual function of the circular, providing administrative guidance and legislative implication meant to bind the public. This complexity underscores the need for scrutiny under administrative law. Next, the appellant contends that the 2003 circular meets the criteria for administrative quasi-legislation. They cite Professor Chen's work on administrative law and highlight the dual function of the circular, providing administrative guidance and legislative implication meant to bind the public. This complexity underscores the need for scrutiny under administrative law. Next, the importance of legal document. The appellant stressed the relevance of document with legal force. References to cases like Diana Jivan Shah, 5 Citibank Berhad, 2009, 5 MLJ 646 and Development and Commercial Bank Berhad, 5 Chia Tian Sui, 1989 to MLJ 496 strengthened their case for challenging the respondent's decision and seeking judicial review within the administrative law framework. Furthermore, the appellant argued that the dismissal decision was made in accordance with statutory law subject to public law review. The presence of statutory conditions and restrictions surrounding the dismissal warrants judicial review. Next, about individual right and judicial review. Authorities like Ahmad Jeffrey bin Muhammad Jahri and civil Lewis judicial remedies in public law support the appellant's contention that decisions affecting individual right or entitlement are subject to judicial review. They criticize the concept of non-justiciability, which has been used to shield public bodies from scrutiny. Next, about challenging interpretation and transparency. Lastly, the appellant challenged the respondent interpretation of the 2003 circular. They claim inconsistency with early order and public policy, highlighting ambiguity around accreditation requirements. They argue that the decision-making process lacked transparency, violating legitimate expectation. Case like Yang Tunku Datuk Seri Nazaruddin Ibni Tuanku Jaafar v. Datuk Bandar Kuala Lumpur in 2003, 5 MLJ 128 underscore the significance of procedural justice and the right to be heard before decision impacting individual. Next, respondent argument. In response to the appellant legal argument, the Federal Council offered a counter perspective. First, they contend that the relationship between the appellant and the respondent is contractual in nature, rather than statutory. Furthermore, they argue that the 2003 circular is purely administrative nature and has no legislative force, as it does not derive from the Perbadanan Tabung Pendidikan Tinggi Nasional Act 1997. Then, arguing that the respondent policy is not justiciable, the Federal Council maintained that it is not subject to judicial review. They claim that material, fact, and evidence have not been disclosed, implying that this compromise the fairness of the decision-making process. The Federal Council also take issue with how the case was handled, pointing out that their submission were made without an affidavit opposing the leave request. They argue that in such circumstance, the court should have treated the leave application as unopposed unless deemed frivolous or an abuse of process. They argue in such circumstance, the court should have treated the leave application as unopposed unless deemed frivolous or an abuse of process. They emphasize how crucial it is to follow procedure in order to preserve the fairness of the decision-making process. Furthermore, they recognize that even though the policy in question may not be considered legally actionable, its execution may be vulnerable to judicial scrutiny if it violates constitutional protection and public right.
The Court of Appeal reviewed the High Court's findings and came to different conclusions. For starters, it regarded the development of the Dasar Pinjaman Boleh Ubah loan policy as an actual policy rather than merely an administrative action. This distinction is important because it indicates that the policy has a greater impact and legal weight. The PTPTN, Perbadanan Tabung Pendidikan Tinggi Nasional, was found to be carrying out its statutory duties under Section 19 of the PTPTN Act 1997. This section is likely to outline the organization's responsibility and authority regarding student loans and education financing. Second, the court ruled that it could intervene in the PTPTN's policy decisions. In other words, the court acknowledged that it has the authority to review and potentially modify PTPTN policies as needed. Concerning the specific exemption conditions mentioned in the 2003 circular, two key requirements were highlighted, which is students who achieve outstanding academic performance and earn a first-class honours degree may be eligible for loan exemption. Second, according to the circular, attending an accredited course is required to qualify for exemptions. Accreditation ensures that an educational institution and its programs adhere to specific quality standards. In summary, the Court of Appeal upheld Teh Guat Hong's claim for exemption for PTPTN loan repayment based on an appropriate interpretation of the 2003 circular. Justice Tengku Maimun Tuan Mat presided over a three-man panel that unanimously ruled in her favour.
Last is identify the supported case applicable. A rule of law, Tengku Muhammad Fakhri Petra Ibni Sultan Ismail Petra is cited in the court's ruling in the Guat Hong Perbadanan Tabung Pendidikan Tinggi Nasional 2015 MLJU 213 to establish guidelines for granting leave for judicial review. The case serves as a significant reference point in the justiciability, procedural fairness, and the appropriate circumstances for granting leave. The court most likely aimed to guarantee uniformity and conformity to accept legal norms when evaluating the case merits. Furthermore, the reference to Tengku Muhammad Fakhri Petra Ibni Sultan Ismail Petra highlight the wider legal framework pertaining justiciability in Malaysian legal system. By contrasting the Malaysian approach with that of other jurisdictions, such as England, the court in Teh Guat Hong Perbadanan Tabung Pendidikan Tinggi Malaysia's legal system, particularly its adherence to constitutional supremacy. The purpose of this comparison is to clarify the distinct factors and responsibilities that influence the Malaysian judiciary's judicial review methodology. In addition, the contrast drawn between the jurisprudential approach of different jurisdictions, particularly between England and Malaysia. Malaysia courts take a more expansive stance towards justiciability under the theory of constitutional supremacy, permitting closer examination of administrative decisions, while England courts adopts a narrow view of justiciability, favoring deference to parliamentary supremacy. This illustrates the essential distinction between the two nations' legal and constitutional framework.